Let me be very clear from the start. This video is not about fear, and it's not about targeting any country or people. It's about patterns. Because in 2026, US immigration enforcement isn't random. It follows priorities, trends, risk profiles, and if you're an immigrant, a family member, or even just paying attention, understanding those patterns matters more than ever. Today, we're examining 7 Asian countries whose nationals are statistically more exposed to deportation enforcement under tightening US immigration policies. Not speculation, not politics, reality. And some of these may surprise you. Before we jump in, this does not mean everyone from these countries is at risk. It means enforcement pressure is unevenly distributed. That distinction matters. Keep watching. First, something most people misunderstand. Deportations don't happen because of nationality alone. They happen because of visa overstays, unauthorized employment, failed asylum claims, criminal records, documentation, inconsistencies, security vetting outcomes. Countries with higher overstay rates or asylum denial rates naturally face more enforcement attention. That's the system. Now, let's examine where enforcement pressure is showing up most often. Number 1. India. India consistently ranks among the highest for US visa overstays. And this is important to say clearly, not because of criminality, but because of volume. India sends some of the largest numbers of legal migrants to the United States every single year. We're talking about H-1B skilled workers in tech, healthcare, and engineering, international students on F-1 visas, family-based migrants waiting years, sometimes decades, for green cards. On paper, everything starts legally. The problem begins when time stretches. Green card backlogs for Indian nationals are among the longest in the US immigration system. Some people wait 10, 15, even 20 years while staying in temporary status. And here's where enforcement risk quietly increases. When a visa expires, even by mistake, when a job ends unexpectedly, when paperwork is delayed or mishandled, legal status can collapse overnight. Not because someone did something wrong, but because the system has no patience for gaps. Especially vulnerable are people whose employment sponsorship ends abruptly due to layoffs, who age out of dependent visas, who overstay while waiting for green card priority dates to move. Once status lapses, the system doesn't pause to understand intent. It flags the case, it records the violation, and enforcement risk increases automatically. That's the part many families don't see coming. Because someone can live legally, work legally, pay taxes for years, and still fall out of status because of timing, not behavior. In 2026, as enforcement tightens, those technical violations matter more than ever. Not loudly, not dramatically, but decisively. Number 2, China. For Chinese nationals, the issue isn't volume, it's security scrutiny. Over the past several years, Chinese immigration cases have faced more intensive background checks, longer security reviews, additional verification at multiple stages of the process. This doesn't mean guilt, it means delay. And delay changes everything. Applications that once took months can now take years. Cases sit in limbo, neither approved nor denied. For many people, that uncertainty becomes the most dangerous place to be. Asylum claims, in particular, face stricter review standards. Claims must meet higher evidentiary thresholds. Inconsistencies, small ones, are examined closely. When an asylum claim fails, the process doesn't simply end. It moves forward. A denied claim often transitions directly into removal proceedings. Not immediately, not dramatically, but eventually, And that delay is what catches people off guard. People build lives while waiting. They find work, they have children, they settle into routines. Then, years later, a decision arrives, and everything changes. Another factor is expanded security vetting tied to academic or research backgrounds, technology-related fields, prior affiliations that require additional review. Again, this is procedural, not personal. But procedures have consequences. A case that lingers too long without resolution can quietly increase exposure to enforcement, especially if temporary protections expire during the wait. In 2026, that risk becomes more pronounced. Not because policies are loud, but because systems are precise. And when a system finally moves, it rarely moves in your favor if your status is unresolved. Number 3. Philippines. The Philippines has one of the highest U.S. overstay rates in Asia. And again, this isn't driven by crime. It's driven by family and time. Many cases are family-based, long-term, quiet, ordinary lives built slowly over years. Parents who came to reunite with relatives. Children who grew up in the U.S. and barely remember anywhere else. Caregivers. Church members. Essential workers. People who didn't arrive with the intention of breaking the law. But here's where the system becomes unforgiving. Family-sponsored immigration from the Philippines often involves very long waiting periods, decades in some cases. And during those waits, temporary visas expire. Extensions get denied. Paperwork falls out of sync. That's how overstays happen, not suddenly but gradually. And the longer someone remains undocumented, the more life they build. They find steady work. They raise children. They become anchors in their communities. Which is exactly why enforcement here is so painful. Because deportation doesn't just remove a person, it dismantles a life. Jobs are lost. Families are split. Children are left behind. Sometimes citizens, sometimes not. What makes this especially difficult in 2026 is that enforcement doesn't weigh emotional history heavily. It weighs status. Years of contribution don't erase an overstay. Good character doesn't override expired documents. The system looks at what's valid on paper, nothing else. That's why Filipino immigrant communities often live with quiet anxiety. Not panic, not headlines, just uncertainty that never fully leaves. And when enforcement finally arrives, it feels sudden, even though the risk was building for years. If you're still watching, here's what you should understand. Most deportations don't happen suddenly. They happen after years of living in uncertainty. Let's continue. Number 4. Vietnamese nationals often face a very specific kind of risk. Not recent violations, not new offenses. The past. Many cases involve older criminal convictions, sometimes from decades ago, post-conviction immigration enforcement that was delayed or paused, reopened deportation agreements between governments. For years, some individuals lived with the assumption that their cases were settled. They served their sentences. They complied with the law afterward. They built families. They stayed out of trouble. But immigration law works differently from criminal law. A conviction, no matter how old, can remain relevant forever in immigration proceedings. And under stricter enforcement, those old records get re-examined. Even offenses that seem minor today, non-violent charges, low-level crimes, youthful mistakes, can suddenly resurface. Not because new crimes were committed, but because enforcement priorities shifted. That's what makes this situation especially hard. There's no warning, no new violation, no second chance to explain context. A record that's been quiet for 20 years can become active again overnight. In 2026, reopened deportation agreements and expanded cooperation mean more cases are reviewed retroactively, quietly, administratively, without headlines. And for the families involved, it feels deeply unfair, because the punishment doesn't feel connected to the present. It feels disconnected in time. But the system doesn't operate on forgiveness. It operates on eligibility. And when eligibility disappears, so does protection. Number 5. South Korea. This part surprises a lot of people, because South Korea is rarely associated with immigration risk. It's a developed country, strong passport, visa-free access to the United States, and that's exactly where the problem begins. South Korea consistently records high overstay numbers, not because of intent, but assumption. Visa-free entry creates a false sense of safety. People arrive legally under programs like ESTA, believing short overstays are overlooked, extensions are informal, enforcement targets, serious cases only. But that's not how the system works. Visa-free does not mean consequence-free. There is no built-in grace period, no automatic forgiveness, no informal correction. Once authorized stay expires, status ends immediately. And unlike some visa categories, visa-free entrants cannot adjust status easily, cannot extend stay inside the US, cannot argue misunderstanding as a defense that makes overstays especially risky. Many cases involve visitors who stay for work opportunities, people waiting on sponsorship that never arrives, individuals who simply miscalculate time limits. The overstay itself may feel minor, but the consequence is not. Overstays under visa-free programs can trigger automatic visa bans, long-term ineligibility for future entry, heightened scrutiny on all future applications, and enforcement doesn't always happen immediately. Sometimes it comes years later, at an airport, during a renewal, or when someone tries to fix their status. That delay is what catches people off guard. They assume silence means safety. It doesn't. Visa-free access is a privilege, not a buffer. And when it expires, the system responds the same way it always does. It records, it flags, and eventually it enforces. Number 6. Nepal. For many Nepali nationals, entry into the United States begins legally, often through student visas, temporary protected pathways, humanitarian or disaster-related programs. At first, everything is compliant, everything is documented, everything appears stable. But the risk doesn't come at entry, it comes at expiration. Temporary protections are exactly that, temporary. When programs like TPS, deferred action, or emergency relief end, legal status doesn't taper off. It collapses, sometimes overnight. And enforcement does not evaluate intention. It evaluates paperwork, a missed renewal, a delayed filing, a misunderstanding of deadlines. That's enough. Student visa holders face a similar pressure point. Many arrive for education, but later lose enrollment status, fall below credit requirements, face financial or family disruptions. Once student status ends, there is no automatic buffer period. Grace windows are narrow, rules are strict, and violations are digitally logged. Number 7. Bangladesh. For many Bangladeshi nationals, the pathway into the US immigration system runs through asylum. Not because it's easy, but because for many, it's the only option available. The challenge isn't always credibility, it's proof. Bangladeshi asylum cases often face high denial rates, intense document verification scrutiny, requests for evidence that are difficult, sometimes impossible, to obtain: political records, police reports, court documents. On paper, these are reasonable requirements. In reality, they can be inaccessible, delayed or contested in origin countries where documentation systems are inconsistent or unreliable. Processing delays stretch cases for years. People wait, they work. They build routines, they raise families, all while their case sits unresolved. And then a decision arrives. If the claim is denied, the transition is immediate. There is no pause to recalibrate. A failed asylum claim doesn't close a file. It transfers it automatically, from protection review to removal proceedings. No warning call, no dramatic confrontation. Just a notice, a court date, a new classification in the system. What makes this especially harsh is timing. Many Bangladeshi nationals have lived in the US for long periods by the time a decision is made. They assume time works in their favor. It doesn't. Time without status doesn't create security. It increases exposure. Once removal proceedings begin, options narrow quickly. Appeals are limited. Discretion is reduced. Detention risk increases. And none of this is framed emotionally by the system. It's administrative. That's the part people don't expect. No drama, no spectacle, just process. Here's the truth. No one explains clearly enough. US deportation enforcement isn't emotional. It isn't personal. It's administrative. Forms, deadlines, status records. And in 2026, those systems are tightening, not loosening. If you're an immigrant, compliance matters more than ever. Legal advice matters early, not late. And if you're just watching from the outside, remember this. Behind every enforcement statistic is a real person with a life built in the gaps of paperwork. That's the part numbers never show. If this video helped clarify things, even slightly, share it with someone who needs information, not fear. And if you want more grounded, fact-based global stories like this, subscribe to Global Pulse. Because understanding the world starts with seeing how systems actually work.